Greetings, everybody, and welcome to Chapter 7. For some reason, my recorder wasn't working in Brightspace today, and I wanted to go ahead and get another Chapter 2 finished, so I'm going to use this method instead, so you won't have a chance to see my old face, but rather you'll be simply looking at the objectives that I'm going to be talking about. The objectives for Chapter 7, the first one is called cyber squatting, or asking what is cyber squatting and when is it illegal. You've probably heard of it, but that's sometimes when you will go to a site, for example, you might be Amazon, but Amazon is spelled differently or is so close, or maybe Amazon.net instead of Amazon.com, or anyway, when a person registers a domain name that is so similar to or confusing with an existing one, with the intent of making a profit off that by actually forcing that company to buy it from you, that would be illegal, and it's called cyber squatting. So people will buy a domain name with the intent of infringing upon another person's or another company's right. It becomes very expensive for that company, because what happens is when they come up with a domain name, they have to think about all the alternatives or ones close to it, so that they can buy those as well to protect themselves. I'm not sure if you ever heard of typo squatting or not, but it happened to me once. I was taking a survey, and I spelled survey S-U-R-V-E-R-Y, put that R in by mistake, a typo, and of course it took me to the survey. Unfortunately, it wasn't the correct survey. It was someone that was using that method of typo squatting, and so as I got into it, I thought, Lord, this really seems getting kind of long and actually getting to asking stuff that I wasn't about to share. So I backed out, but it was too late because I'd already signed up for some stuff that I didn't want, I think. But anyway, that's called typo squatting, a form of cyber squatting. The second objective talks about the steps taken to protect intellectual property. Most of you are aware probably that the United States is in the forefront in the creation of intellectual property. We have problems with that all the time with other governments, especially, or other companies from other countries, especially China, for example, stealing that from us and reproducing it. A huge billion-dollar loss for the people that have created that for the United States. So the government has really worked hard in that arena and trying to protect those rights. If you look at a landmark case found on page 168 of your text, you'll get a pretty good glimpse of what happened with what the United States is doing in this arena to protect our creators of this intellectual property. It's a landmark case, and if you remember, a landmark definition was a court case like Roe versus Wade, for example, or Brown versus Ferguson. I don't remember the court case now, but anyway, they're court cases that really affect society as a whole. And in this case, if other countries have bought into it, it would affect them as well. But anyway, the purpose is to curb unauthorized copying of protected property. Objective number 3 talks about the law protecting a person's electronic communications from being intercepted or accessed. In the past, of course, it is not legal to steal someone else's private correspondence and so forth, but we have what they call the Electronic Communications Privacy Act, and it was amended to include all forms of communication, including electronic communications. And this was really before social media became so prevalent. However, the law has been applying that act to social media as well. Number 4 talks about your internet provided services and whether they're liable or not for allowing anonymous postings of defamatory statements. If you remember from a previous chapter, chapter 4, I believe, it talks about when you actually repeat defamatory remarks, even though you didn't make them originally, you could be held just as liable. And this included the print and news media as well. The IPS, however, based on the Communications Decency Act, holds that the IPS will be treated differently, and they are not held liable for defamatory statements made by third parties, keeping in mind, of course, that if you had a case, is you could go to court and attempt to get those names from the IPS, though you would expect a fight. And finally, we're talking about online tracking of users. If you've ever gone to Amazon and, for example, you shop for a pair of shoes or a pair of slacks or a television set or whatever, and then bought or not didn't make any difference. Next time you log in, guess what? you're going to see slacks, shoes, and television sets right up front, prominent. So it's pretty obvious that that company has done something that they really know what you're looking for. They're called cookies, and it's an invisible file that's on that they put on your computer, in which as soon as you log in, they already know, for example, what your preferences are. So the advantages would be, of course, is that when you log in, they already know what you like and don't like, or I shouldn't say don't like, but what you like because of your past experience. The disadvantage, of course, is that when you log in, they already know what your preferences are. So the thing is how much privacy are you willing to give up for that advantage of shopping online? Anyway, that's the extent of this chapter. I wish you luck in it, and if you have any questions, let me know, and you didn't have to look at my face this time.